But I'm going to go ahead and get our panel started for this morning because I know that this is a lot to cover in a very short time. So I'm hoping that as sort of a highlighted overview, and I don't know if anybody was able to catch the previous panel. I think we started talking about what it takes to win cases in court from the psychosocial perspective. So I think this will be a good opportunity for us to move into what it takes to run these cases through the legal perspective. So, and we are dealing with whistleblowers who are dealing with judicial proceedings all around the world. That's why the previous panel, they talked a little bit about tribunals in the UK. So we need to really understand what are the protective laws for whistleblowers, and then how do you document retaliation, the injury causes, and the level of evidence necessary to win relief for damages. I mean, I think critical to the success of disclosure is knowing how to hire an attorney, where to bring a complaint, who lends support, what constitutes a valid complaint, when are you ready to make that disclosure, and why is there harm? So this is a multifaceted issue with multifaceted questions that employees who are really not the experts in their field don't really know what to do. And most employees who make a disclosure are not themselves attorneys. There are some, but that's not the standard. So I think the questions that we're going to focus on with this panel is really understanding what does it take? What evidence do we need? And and there's Tess. So I said, it says that this is Georgina Halford Hall, but I know it's Tessa Munt. So welcome. So so to begin, why don't I ask each of you just to kind of give me a quick who you are, and I believe you're all attorneys. I don't know about Tessa. No, but if you could give me a little bit about your name, where you're from, and your field of expertise. So why don't we begin with Tom? You're on.
Thanks for organizing this. Jackie, I've been sharing it with everybody that I know who's in the whistleblower community, saying that this is just something essential to be understanding the world that we're all participating in from our own fields of expertise. The Government Accountability Project has been around for a little over 40 years, I think 42 or 43 years. In our current generation, which has been about 40 of the 43 years, we've been a legal services organization for whistleblowers, connected with Antioch School of Law and then later DC School of Law to provide no or low cost representation to whistleblowers, both to defend them against retaliation and to help them make a difference. For their dissent to have an impact. So I've worked with about 8,000 whistleblowers over those 4 decades, formally, excuse me, or informally. The other things that we do at GAP are fighting ceaselessly, relentlessly to get stronger free speech laws. So we've been kind of on the front lines to get over 3 dozen free speech laws from Washington, DC to the United Nations. And are currently involved in about 40 bills before Congress, about half a dozen of them, which I think are just very fundamental for freedom of speech in our country. And then the final thing we do is share our lessons learned by writing books and survival guides and law review articles and doing the law school clinic and accepting the invitation from anybody who will listen to us like you offered today.
Well, thank you. I appreciate you joining us. Jason.
Hi, good morning. This is Jason Zuckerman. And I just want to say too, it's such an honor to be here because I speak at a lot of CLEs, mainly the lawyers, and we get all into the law and we get in those weeds and we forget what this is really about, right? It's people who put their neck on the line, spoke up, and have been harmed. And I got to catch a lot of the earlier panel this morning and to hear about what is the long-term impact on people. And there's been an act of retaliation I see that with my clients, and as an advocate, it's so important every once in a while to put aside the law and to say, you know, what's going on with my client, what's going on in their head. So if this is worthwhile. But who am I? My name is Jason Zuckerman. I represent a lot of whistleblowers throughout the U.S., mainly in claims of retaliation, but I also represent whistleblowers at the SEC, CFTC, IRS, and under the QUETAM provisions of the False Claims Act. I've mainly been in private practice, but I had the honor during President Obama's administration to work in a high-level position at the U.S. Office of Special Counsel. So that's my background.
Thank you. And Richard?
Good morning. Well, I also want to thank you, Jackie, and the rest of the team there for inviting me. I agree with Tom. This is a important conference. I hope it's going to occur annually. And I also agree with Jason that it's very important to hear about psychosocial impacts and other issues that whistleblowers face, as they go on this journey. So my name is Richard Condit. I am the co-chair of the whistleblower rights practice at the law firm Marion Scallett, which is based in Washington, D.C. I have been working with whistleblowers for probably more than 30 years now. I've worked at the Government Accountability Project. I've worked at Public Employees for Environmental Responsibility and with other NGOs and in private practice. And now I'm currently at the Marion Scallett firm. We work on False Claims Act matters as well as whistleblower retaliation matters in all areas, and happy to contribute whatever I can to this discussion this morning.
Thank you. And I also want to thank you because Mary Scallett is our lead sponsor for this event. We are very grateful, and because so much of being able to make this happen has relied on the kindness and donation of strangers as well as our own community. So thank you for that, for making that happen. So I'm going to ask Tessa Munt who jumped in at the last minute. So I appreciate that, Tessa. I've seen you speak before, but could you give a quick introduction from across the pond? You're on mute.
Yeah, thank you very much indeed. As you say, I'm stepping in for Georgina Holford Hall, who's lost her voice, which is a misfortune. And I'm sorry that you haven't got her, but you got me instead. So here in the UK, we're already a good way through our day. But as you probably know, the UK introduced laws to protect workers against retaliation in as early as 1998. But the impact of the Public Interest Disclosure Act, PIDA, which is the act that we have, it really came with very ambitious expectations that it would drive cultural change relating to the treatment of whistleblowing and those who spoke out. But actually, unlike most of the rest of our employment legislation, the act itself received terribly little attention. And to this day, I think very few people actually understand the legislation and the rather feeble protections that we have. And even attempts to improve worker protection haven't really improved the legislation at all. So many workers who raise their concerns do so with little or no understanding of their rights or of their organisation's responsibility. And of course, commonly across the pond as well, most whistleblowing includes allegations of crimes and corruption and cover-ups that should be sorted out. So our UK tribunal system is only concerned with breach of contract. There's no investigation of the allegations of wrongdoing, only of the conduct of the employer and the employee in relation to that loss or breach of contract. So we think that the existing legislation has served really to stifle speaking up in this country and has emboldened organisations to flout their legal obligations completely. They don't investigate concerns, they don't protect those who speak up, and we're continuing with our campaign to make sure that we introduce the Office of the Whistleblower. We see the office actually being the opportunity to revolutionise speaking up by extending protection to every citizen. And that will actually, it should provide vital information for the government and for law enforcement and regulators so that they can intercept criminality. It's on that basis that we've always said, haven't we, that the whistleblower is the CEO's best friend, the chief executive's best friend. But actually, it's really important that government and law enforcement and the regulators gather up that information as well, and they can stop the stuff that generally endangers the public and provides, make sure that they provide some proper protection, which is what the Officer for the Whistleblower will do. I would just say Whistleblowers UK is a not-for-profit organisation. I'm the chair, Georgina is the chief executive, and all we're trying to do is transform the way that people in this country think about whistleblowing. So I'll direct you to our website if you're interested. It's wbuk.org. But otherwise, I'm absolutely thrilled to bits to be speaking to you today, and thank you very much indeed for inviting us.
No, thank you. I think the universality of whistleblower retaliation and the harm people suffer, just like what we've seen with combat vets and we've done with militaries across the globe, is we recognize that when the war is over, the trauma is long lasting. And so those impacts and the way that infects the employee in the workplace, I think is important. And Tom, you hinted at, so you and GAP have been doing this for 40 years. What are some of the key ingredients that you think for whistleblower protections to be effective?
That's a very basic and wonderful question, because we've had a legal revolution in free speech rights for whistleblowers. When I first came to GAP in 1979, the US was the only country in the world that had them. Now there's 48 nations that have dedicated whistleblower laws. With the European Union Whistleblower Directive, it's going to be 62. It's a phenomenon, but you know, it's a legal revolution. And really the question is, who's dying in battle? And unfortunately, the primary casualties are the whistleblowers coming out of this legal revolution to create freedom of speech. It's the we've pioneered a very, very significant phenomenon, but we've got a long way to go before this principle reflects reality. And GAP has done significant work to develop what are the best practices for a credible whistleblower law. I think of them as whistleblower laws like a free speech shield. And you go into battle with a metal shield. It's dangerous, but you got a fighting chance to survive, to defend yourself. And then go into battle with a cardboard shield. No matter how beautifully it's decorated, you're going to die. And too many whistleblower laws are cardboard shields. They promise freedom of speech. And really, they're vehicles that rubber stamp any retaliation that the employee challenges, and it means they're actually dangerous to freedom of speech. And so we put together the criteria to distinguish between metal shields and cardboard shields, worked with the International Bar Association, and they're kind of the consensus global criteria. And they've got certain basic principles. The first is that the rights are there when you need them. This means that you can blow the whistle to any audience where the information would make a difference. Some whistleblower laws just say, yeah, you've got freedom of speech if you're channeled to a particular government audience that may be suspect. It doesn't matter whether or not you're pointing the finger or just performing your professional duties when you communicate information that's protected by whistleblower laws. You're not looking for a fight, you're just playing it straight. You can't have loopholes that cancel out those contexts, which a lot of the laws do. The laws have to protect you for the subject matters that are significant. The laws have to override gag orders that would cancel your free speech rights. The laws have to offer you the chance to exercise your free speech rights confidentially so that you don't risk retaliation by being exposed. That's the first basic principle. You have the rights The rights are there when you need them. It includes providing support services for those rights so people understand the nature of them and don't have to fly blind when they haven't gotten the specialized training. The second basic principle is fair rules of the game to prevail. That's the burdens of proof. The amount of time that you have to act on your rights, not creating unrealistic procedural prerequisites and roadblocks before your rights become even relevant for you. Fair rules on how much evidence each side has to prove to prevail in the case. The law has to be carefully structured so that it's a fair chance for justice. If it's arbitrary and either the rules are rigged so that it's not realistic to be able to prove your rights, or it's just arbitrary and it's open to whatever the judge wants to do. It's the laws may well be false advertising. The third thing that I think is extremely significant is that you have effective due process, a fair day in court that's not going to be controlled or so vulnerable to political pressures, where what matters is the evidence and the truth rather than the context for asserting your rights. The fourth one that's significant is that if you win your case, you really win. That you call them make whole remedies. They're not worse off than if you'd failed to exercise your rights. A lot of these laws don't do that. And it means that you end up losing by winning. You won your case and your life is still not anywhere close to, you're a big loser in life because your legal rights weren't there when you needed them. And the final thing that probably equally significant in convincing people to blow the whistle to all the other things which are about defending themselves is that you have an effective chance to make a difference. The studies consistently have shown that the number 2 reason why would-be whistleblowers remain silent observers, keep their mouth shut, is fear of retaliation. The number 1 reason is that it won't make a difference. It won't matter. And really, when you think about it, that's pretty rational. Most people are gutsy, they're courageous. A lot of folks are willing to risk their lives to defend their country. But if the only thing you're going to accomplish by blowing the whistle and beating your head against the bureaucratic wall is to crack your own skull, it's almost like you have to have a martyr complex. People will take this risk if they think it's going to accomplish something, if there's a point to it. And that's the 5th thing that you have to have for an effective whistleblower law. It's a credible channel to work with the whistleblower on the evidence that they disclose, rather than just receiving it and the whistleblower never even knows what happened to it. So those are the things that I'd say are the most significant principles, Jackie.
Okay, thank you, Tom. I think that was a really good overview. And so I want to start to drill into that overview now with the next part of my question. So Jason, you and I've had a little bit of conversation, some back and forth, because you not too long ago posted about a case that you won that was very successful. I know it was in the news, but I'll let you discuss if you feel like it, that case. But let's drill into evidence. What evidence is necessary to win awards now for the retaliation, for the emotional pain and suffering that helps make people whole?
Yeah, so I won't go into anything I've been involved with a client, just till I have a client's consent. But let me say a few things. I think it's easy as a lawyer to really have your eyes on how do I win the case, right? And we don't think enough early on about how do I get my client an award that makes them whole. And so what I've learned to do early on, before I even bring my client's complaint, is to really do my homework, meaning I try to interview a lot of witnesses, their spouse, anyone they're very close with, maybe people that they had worked with for years. And I try to get the before the act of retaliation and the after. What was the impact? And get really specific, because I want to have a lot of evidence to show that they, you know, a person has certain hobbies, they like to spend time with their spouse, with their children, and then all of a sudden, this horrible thing that happened to them has become all consuming and has prevented them from really being able to enjoy themselves. Now, where a client is at a point that they really can't be part of the workforce and you know, aren't able to get out of bed, I strongly advise that client to get help from a proper certified professional. And I might offer up that professional's specific expert opinion at some point. Keep in mind though, if you're going to do that and you're going to waive the right to keep that information completely confidential, you want to be careful, obviously, what you say and be aware that it might be offered up into evidence. But I want to look not only at the impact on my client's mental health, but really the impact on my client's future earnings, right? So again, I think under these various laws, and it really varies what you can get, but under a lot of them, you can get non-economic damages for harm to an individual's professional reputation and for emotional distress. Some U.S. courts of appeals have held that to get over $100,000 worth of emotional distress damages, you have to offer up the opinion of an expert. Many courts, though, in the past few years have really gone the other way. And if you can offer up very specific evidence from your client and from other people that they know well, you are able to get more. But just having a lot of affidavits, a lot of details. One of the things I might do early on is I'll hire what's called a vocational rehabilitation expert. And my client really was an expert in their area and was at their and was earning a lot, you know, was basically at their peak in earnings. And all of a sudden they can't get other work like that. I'll have that person do an interview with my client, walk through what are the efforts my client made to get work, how many openings are there in that area, and really have that expert prepare a very detailed opinion about what is the harm to my client long term. It might be that my client won't ever get a job that good and is going to have to earn a lot less. And then I try to get an economist to offer up an opinion of what will be that economic loss for the remainder of my client's professional career. So it's really about making sure to do your homework, having that evidence, so it's not just your client's word about what has happened to them. I hope I've answered the question.
No, I think that really does help, because I think that's the, you know, that's part of what is the secret sauce, right? So understanding evidence. And just maybe a quick follow-up. Is there an explanation for level of evidence? Like, what's the difference between a preponderance, clear and convincing, reasonable doubt? How do we understand these terms? Because that gets thrown at us as whistleblowers. And if it wasn't for my work with the VA, I would never have known, like, oh, wait, I know that means something.
Mindful of all the issues you want to cover and other panels, like I could use an hour to answer it, but here's how I might answer if this is okay. The problem, and we owe it, you know, to the Government Accountability Project and the other great advocates for creating so many good laws. And that's a wonderful thing, not something to complain about, but having all those laws out there means you really have to do your homework. And it's so hard, I think, to do this when you're pro se, even if you are a lawyer, if you haven't done a lot of these cases, you might know this. It's so critical to know at the beginning, okay, what are all my options? And making sure you pick the options that are going to get you probably the best result, but also to the issue you just brought up, one of the things you want to look at is what is your client's burden, because you could have an overlapping law. I'll give you an example. If you work at a US government contractor and there's an act of retaliation because you blow the whistle that your employer, was lying to US government. They were supposed to provide a plane that worked well, and it had all these issues that they had. Okay, you blow the whistle. You have two overlapping options: the Anti-Retaliation Provision of the False Claims Act and the Anti-Retaliation Provision of the NDAA. The plaintiff's burden under the NDAA, like under the Whistleblower Protection Act that it is modeled upon, is just to show that their whistleblowing had any impact whatsoever on that adverse action. But under the Anti-Retaliation Provision of the False Claims Act, which was enacted in 1986, it uses the words because of. And when the words because of apply, are in any anti-retaliation law under some holdings of our current Supreme Court, you have to show what's known as but for causation. Now, the Supreme Court clarified about a year ago that does not mean you have to show that you're blowing the whistle was the only reason for the adverse action, but it is a higher burden. So if a client were to come to me and they work at a government contractor, right? There's been an act of retaliation because they blew the whistle. I'm going to look at both an NDAA claim and an FCA claim. I can start with an NDAA claim, which requires me to go to the Office of Inspector General. Once I've been able to exhaust there, I can add a claim under the Anti-Retaliation Provision of the False Claims Act, which allows me actually to get a higher amount of my client's back pay. But my point here is make sure you know all of your options and have a good plan so you're able to take advantage of all those options. For example, in some states, like the state of California, and that's where you see pretty much the highest verdicts, you can bring a claim under both US law and under state law. So if you have a claim, let's say, under the Anti-Retaliation Provision of the Sarbanes-Oxley Act, because you blew the whistle about a violation SEC rule, you can start with a claim at the DOL, bring that into court in the state of California, add a claim under California law, which gives you the option to get punitive damages, which you don't have an option to get in the Sarbanes-Oxley Act. So really, it's key to have the plan to get a very good burden, because you want that burden for your client to be as low as possible and for the employer to have an elevated burden. But you can use all those options and hopefully get a very good result for your client. And just one last thing, check if the law makes you go to arbitration. Unfortunately, many of these laws, if you have an arbitration agreement with your employer, the Supreme Court views the U.S. Arbitration Act very broadly and will make you go to arbitration. Some laws, thanks to the hard work of Mr. Devine, who made sure to add to the Anti-Retaliation Provision of the Sarbanes-Oxley Act about 11 years ago, a specific clause saying that arbitration agreements do not apply. If you can get one of those laws, it's great, because you don't want to go to arbitration and you're likely to get more if you can get before a jury.
All right, well, thank you. I know that was a tough question that I put you on.
Jackie, I can add just a little bit to directly answer your query about what's preponderance of the evidence and what's clear and convincing evidence.
Sure.
Preponderance of the evidence is a simple majority. Clear and convincing evidence is 70 to 80% of the evidence in the record. And so that's one of the battles that we fought and won, was that the employer has to prove by clear and convincing evidence, 70 to 80% of the evidence in the record, their pretext or their independent justification when the whistleblowers demonstrated relevance. And Actually, these provisions, we call them, nicknamed the anti-gag provisions, but they also are provisions that say the free speech due process rights override employer-controlled arbitrations. Those are in virtually every whistleblower law since 2000. So all the modern ones, the statutory free speech rights override the mandatory arbitrations. They're kind of like kangaroo courts.
No, thank you for that clarification. That was really helpful. So Richard, you've also been very successful in litigating whistleblower complaints. What advice would you have if an employee was interested in settling their case, so settling before taking this all the way to a trial? And what about these NDAs and gag orders? Are they good to sign one? Are they always legal to be asked to sign one? I mean, what should people know about gag orders as well?
Mm-hmm. Yeah, great question. So if someone is interested in settling their case, I would say the first thing you have to understand is to work with your attorney very closely to know what are the strengths and weaknesses of your case. And you really need to have your attorney be candid with you about that. And you need to express an interest in a candid observation from your attorney, because that is what is really going to guide the approach that you may take to trying to settle the case. You also, though, want to understand what the vulnerabilities of the employer or the other side's case is as well. What does the attorney think are the weaknesses there? And then you want to consider the intangibles, things like what effect would publicity have if the case went forward, or what effect would there be if there were further investigations that were triggered by the activity that you were engaged in? And then what's the time commitment and the costs? And I think that one of the things that we all as attorneys have to do a better job of is explaining to clients what the level of commitment is when you're involved in one of these activities. I know Jason does that. I know that Tom does that. You know, folks that have been in the trenches a long time on these issues are really usually making a point to be very thoughtful about describing what it takes. But to be brief, I mean, it's typically, even in just a retaliation case, it's a multi-year effort. Mm-hmm. And the client has to be prepared for the fact that that's what it's going to be. And we, the lawyers, rely on our clients a lot to be our guides, to help us understand the facts, to benefit from their expertise in whatever area they've been blowing the whistle on. And so it means on the part of the client, a very significant time commitment and emotional commitment that is associated with this. Now, we as lawyers may be able to look at things a little more objectively as we're proceeding. We have to realize, though, that it's very hard for a client to sit there and hear the other side either lie or say things that are derogatory about your client. I mean, it's very personal. So these are all things that I try to do in terms of preparing someone to understand their strengths and weaknesses, what it takes to go forward, what it takes to be successful, and what the strengths and weaknesses of the case are. So all of those elements that I've just described are very critical factors in evaluating, settlement. And then, if you're going to get into a settlement discussion, if you're actually in negotiations or you're thinking about negotiating, you want to be very thoughtful about, okay, what would the scope of the settlement be? Will there be restrictions? And this is getting to your second question in a moment. Almost all employers are going to insist on some kind of restriction. You're not going to return to the job, so we're going to pay you off. You're not going to talk about the terms of the settlement. You are not going to disparage the company or any of its employees. You are, going to, do other things. Maybe you won't work for the company or its affiliates in the future. So there will be restrictions that will come up as part of the negotiation. Employers are always asking for one or all of these things. And there may also be, penalties for violating restrictions that are attempted to be negotiated by, the other side. Will there be liquidated damages or some other, penalty that could be associated with violating any of these things? So whether or not the client wishes to engage in accept any of these restrictions is really entirely up to them. And they need, again, to have a candid conversation with the lawyer about what are the pros and cons for them personally and for their personal goals of addressing any of these restrictions. So to your question about gag orders or non-disclosures, I would say that it really depends on the individual situation and what they hope to achieve. Typically, if you're in the private sector setting, so it's a little different between a government, whistleblower setting and a private sector setting. If you're in a private sector setting, typically, companies are going to ask for and want some type of provision that will stop the conversation from occurring with respect to the issues that the individual raised. And the employee has to decide, is that acceptable? Is it not acceptable? Do the terms allow me to move on in my life in the way that I'd like to? Or are they too restrictive that I can't move on with them? And the attorney and the client have to really work together to understand what the client needs and wants and what the pros and cons are of each of these components of a settlement.
Yeah, so I think.
And can I add?
Oh, sure.
Can I add
Absolutely.
two things very, very quickly? I just want to say on the issue of an NDA, this is one area where there's good news. I've got some scars and a lot of PTSD from employers suing the heck out of me, trying to go after my law license because I had the gall to help my clients blow the whistle to the SEC, to the Department of Justice, to OIGs. But this was a while ago. In the past few years, the law in this area has gotten so much better. There are many, many agencies, including the US SEC, all the OIGs that have said, no more. If you want to get any work from the US government, if you want to have any kind of a contract with the US Department of Defense, you are not going to require your employees to agree to hide issues and not to be able to report. So a lot of those NDAs, you really have to look at them. I don't give a darn anymore what they say because there are things in there that are not lawful, that are not valid. You always have the right to report a violation of law to its government. Now, if it involves certain information, if it's classified, for example, you got to be careful how you blow the whistle and you want to get legal advice on that. But even if it's classified, there are some options for you to blow the whistle in a lawful way. So this is one area that's really good. Employers cannot use NDAs anymore. Even after you resolve your claim, you still will often have the right to report a violation of law to its government. Not to go to the media, but to go to the government, to go to the right people. The other thing I want to just bring up really quickly is what we heard earlier out of Richard, which I can't agree more with, which is that your lawyer needs to really look at it in a way that gives you an honest opinion about what's good, what's bad. But I'll be honest with you, Jackie, that one of the things that your organization, I think, could be helpful with is to help our bar work with our clients better, right? When an individual has gone through really bad PTSD, years and years worth of retaliation, the impact it has on them, when they hear from their lawyer that their claim is not a slam dunk, that they're not going to get millions of dollars, that it's not black and white, and that the law is not as good as we would hope it would be, that can be very hard for that client to hear. So one of the things that I think would help would be for you to give our bar, the skills to work with people who've been through that horrible experience, so we could give them very good legal advice that they can actually rely upon, because as you said earlier, it is really hard when you've been through that to hear from anyone that the claim is not a slam dunk.
You know, I appreciate that. That's and I think we're seeing that, by the way. I am seeing the Q&A, and a good number of the questions that are coming in are about, you know, that this, and I think one writer here, it's anonymous, says this really well, that whistleblowing and fighting corruption abuse can be a full-time job, and the mental stress alone can be sabotaging and traumatizing for one's performance. And then somebody else is asking about, you know, is it harmful to speak in public? And how do you balance out your need to really want to tell your story to anyone who will listen to what you need to do in a court case? And I know some of these cases even require you to not even tell your spouse what's going on. And then, and can there be restrictions on companies that that have been found guilty? How do you balance out all of those desires for what it means to win your case, to then what does the law allow and what are you required to deal with? And Jason, I would absolutely love to work with any bar association and anywhere in the country and provide any kind of support that we could and do this training. So I'm all in.
Well,
Actually, I add one other area where we lawyers could use some support in their relationships with their clients, the whistleblowers, is it's a surprising challenge, but one that I've found to be the case. You know, and it's unfortunate, is sometimes it's hard to stop fighting, and that means it's traumatic. It's an emotional challenge to win the case. That somebody who's been fighting the righteous cause for years and then refused to back off, it's hard to accept that it's over with, that you've won. Or that, and that's why sometimes the settlements are hard. Well, I didn't win 100%. You only won 90%. It's unlikely that if the company weren't willing to surrender to you or the employer weren't willing to surrender, it's unlikely you'd win more than 0%. So, you know, take your victory. But sometimes it's just so painful for whistleblowers to accept that. And so I feel like the closure process at the end of the experience is a really high stakes stage of whistleblowing, regardless of how the legal outcome is going.
So I think you just brought up a really great point about closure. And I've seen some questions as well in the Q&A about appealing a case, and then I think I lost it. But then we just had a question about, so you think you've won your case, you think your case is over, but then you discover that the workplace bullying, the retaliation, or the things that were originally concealed, those things are still ongoing. I mean, then what do? Do you reopen a case or bring a new case? I mean, I know I've experienced that too, where I thought it was all over. Actually, Gap announced that I won my case, and a news outlet covered the story, didn't even publish anybody else's name but mine, but then were inundated with requests from my retaliator that the story be taken down, and Military Times took down the story. So it was another example of retaliation post my winning the case. How do people handle that? Do they reopen cases? And do they appeal cases that they've lost?
Well, you know, Jackie, on the question of how do you deal with the circumstances of the retaliation or bullying or other things if they continue after the case is concluded, I mean, I think that's, you know, a case-by-case evaluation. I would be willing to bring another case quickly if the circumstances were sufficient. But what every whistleblower needs to understand, every client needs to understand, is there's going to be a certain amount of rough and tumble that's going to occur. If you go back to the same organization that you just prevailed over, you, unless the personnel have changed significantly, you are likely to experience some negative impact from that organization. And so you have to be prepared to do that. And that's part of the evaluation of how do you resolve the case. Do you resolve the case by going back? Do you resolve the case by moving on and going somewhere else? You know, these are very important factors to consider. And I would say in considering whether or not you can go back, you have to understand that you're going to get a certain amount of abuse, if you will, that may not be actionable. It may not rise to the level of something that a lawyer can actually make a case out of. Now that the opposite could be true as well, and I'd be willing to do it in a heartbeat if the circumstances were there. But that is part of, unfortunately, the burden that one faces if one goes back to, you know, the employer or the organization they were working for, I think.
Yeah.
Jackie, your question just strikes at a basic truth about human nature. It's not really realistic to go back to work for a boss you just defeated in a lawsuit.
Right.
It's just not. You know, their human reaction is going to be more intense than to retaliate against you than before you defeated them. We actually did a study once of early in the Civil Service Reform Act of people who had won their cases and been reinstated, and half of them were fired again within 2 months. And so that means that winning your case, it's not just like you won your case and you can revert back to the life you had previously. Winning your case creates an opportunity for a fresh start. If you're being realistic. And it's possible because there have been changes in personnel and such a vindication and with the way you handled your past whistleblowing, you didn't burn bridges, that you could go home. But that's the rare exception. And so we got into the Whistleblower Protection Act. There's a legal transfer preference for a fresh start within the organization in a different unit. But your reputation travels with you. That's only partially helpful. It's a big part of winning the case is setting up the opportunities for the next phase for a fresh start. Sometimes part of the settlement will be an Intergovernmental Personnel Act reassignment, where the federal government pays you to go to work for a state or local government or an NGO, and you start developing roots in the community that appreciates the whistleblowing that you did rather than having been threatened by it. Sometimes it'll be to get training for a different field of expertise. A number of my whistleblower clients have then attended law school and become whistleblower lawyers. It's very difficult to expect that winning your case means you'll be able to go back to the way it was. So part of that victory means strategically setting up the new phase of your life.
Yeah. And if I could just add one thing to what you asked, Jackie. Let's say that the issue you blew the whistle about, let's say there's an issue that impacts public health, for example, right? So you have a claim of retaliation, it's resolved, it's over. But as you brought up, Jackie, the underlying issue is still ongoing and there's that harm. After your case is resolved, there's a lot you can do to still work on those issues. You could work with people on the Hill. You get involved in some oversight, let's say oversight of the FDA, oversight of Health and Human Services. You can go to journalists and help them learn more about these issues so they can write articles that really will bring it to light. You can work with other people who've blown the whistle. You can go to an Office of Inspector General. And there are some options now, including at the SEC, for you to blow the whistle without having to reveal your name. For example, with the help of a lawyer, you certainly have the option to go to an Office of Inspector General, and you can make an anonymous complaint. So, I've had many clients who, after we resolved the claim of retaliation, the actual issue that they blew the whistle about, they still work on that issue for years and years. So there are a lot of ways that people can get involved in trying to advance, the public interest after they resolve their claim. It's my own view that people who do that, it's good if you can do it without having your name out there, because when you apply for work, I'm not sure you want a prospective employer, to see all these articles about you. It's not the end of the world. I had a client who worked at a bank, blew the whistle on sign, it was in the headlines in the Wall Street Journal. He moved on. He's not at a bank. He works at a hedge fund. I mean, I've had many clients who did blow the whistle, who act as a witness at a hearing on the Hill. I mean, you can be out there and get reemployed, but let's be honest, it can be very hard for you to get reemployed in your field if you're out there a lot. But I think there are many ways to get involved and to work to advance the public interest without having to get your name in the press.
No, I would agree. And I think Tessa, Georgina, and I have connected across the water, so to speak, because I think what Jason just said is so important. I think it's that taking your experience and making meaning out of it. And I know there are some efforts, Tessa, in the UK, and I think the perspective that Whistleblowing UK takes is to really look at sort of the trauma and the psychosocial that's behind some of this. Would you like to share some of the things that you're doing and provide us maybe a little bit more of an international perspective on some of these laws?
Well, I suspect it's common, isn't it, across the world, in that all of us deal with people who have been highly traumatized, as has been mentioned already. But actually, it's the gap that is left sometimes in the life of the whistleblower when they are no longer dealing on a daily or a weekly basis with their lawyer and others, and pulling together evidence and pulling together, I mean, all of that information. I know from at a first-hand level that, I spent 5 years of my life pulling together the court documents for somebody else and making sure that our solicitor, or his solicitor, and I was helping, began to feel like my solicitor, but make sure that everything was accurate, everything was right, spot on, because I appreciate that, the attorneys in the world don't have the time necessarily to get the really fine points sorted out. And it's very often, if you've got a good client or a good somebody working alongside, we call them Mackenzie friend in this country. I don't know whether you have the same phrase there, but somebody who can go to court and shovel documents around and support you as an individual. Doesn't happen the same way quite in our tribunals, but this can be all life consuming. Yeah. All life consuming for a very long time, a very long period in your life. And I think that therefore, when there is a resolution, whether it's satisfactory or not, there is a walloping great gap in people's lives. And the psychological damage to somebody, firstly, of maybe achieving something, if their expectations were too great and they've got something, the 90% that you were referring to, they sometimes forget that they could have had 1% or 5% or none. And so there is that is a damaging verdict to them. They think they haven't got enough. Whereas maybe they got the best that they could possibly hope for. Certainly in this country, it's appallingly dissatisfactory because of the peculiarities of our law and the inadequacies until such time as we get new law in place. But the person who can be damaged and have a massive gap in their lives, what we really need to do is make sure that they do, if they can, bring themselves to a place where it's finished. Now, for some people, that can be in the glories of something like the Ellen Brockovich film or something like the Catherine Gum film, whatever, all of those films that are fantastically interesting people on a level They may be dramatized, they may take away some of the factual stuff, but at least they give people a feeling that others are getting involved and understand the situation, understand the burning injustices. But for a lot of other people, it's just a massive gap and life suddenly collapses, and you come to the reality, as happens in other walks of life, but not so obviously. And perhaps being a politician, having been elected and then lost my seat, believe me, that's a whopping gap that suddenly happens. What, it's a cliff edge. And the same thing happens to whistleblowers. It's an absolute cliff edge, and you have to find some other way. And if you're not film story material, you have to find another way to be able to direct your energies. I would just say there's one other thing I would say, and that is part of the work that we do. Of course, we don't do the prep work for people who are going to tribunal or any other sort of court proceeding. We don't do that work. We hand people with really good cases and sometimes cases that are interesting and may feel more fragile to us, but we hand them on to lawyers. And those lawyers, those attorneys are the people who advise somebody whether they have a case or not. And that can be a bit of a cliff edge thing as well. If you've gone through the trauma and it's taken, many months, many years sometimes to grow to the point where you can speak up. And then the lawyer says, there's nowhere to go with this at the moment. The best thing you can do is fight for better laws, but you may not be in that place if you're the whistleblower. You may be just feeling as though there's no one on your side. And I think that's where we have to be good at listening.
So I think you just reminded me of one of the questions that I wanted to ask. So of course, turning my attention back to the three very, very wonderful attorneys that we have here. This would never be any of you, but I've had people who have said to me, oh, my attorney just didn't know how to represent me. They didn't understand my case. They made mistakes. I mean, I can go on and on. Nobody would take my appeal. So how do you hire an attorney? How do you know? How do you feel comfortable? Because that's something people do talk to me about, like, oh, I don't know if I trust my attorney. How does somebody know that you're the good guy, that you're properly representing them? Or, don't hire your divorce attorney to bring your Quitom case. I mean, trust me, well, no, I have an attorney. He handled my divorce. No, you don't have an attorney for this. How do you parse that out? How do you find a good attorney? How do you know you have the right attorney? How do you know when to fire your attorney?
So, Jackie, attorneys are not generic, right?
No.
It's not an off-the-shelf commodity. And so, what I would say to folks is, one of the important factors is you have to really consider experience. Are the folks that you're interviewing for counsel or the firm or lawyer you're looking at, do they have experience in the area? You may not know as a layperson, like exactly how would a case take shape and where would it go and all that, but do they have experience in the area that you've blown the whistle about? Or in a similar area, such that you can have some confidence that they will get it and be able to understand what you're talking about. I think the concern that you raised a minute ago about my attorney doesn't understand me is a very legitimate one. And part of that is a communication gap sometimes between the attorney and the client. Clients sometimes come in with very high levels of expertise in very particular areas, and they start speaking in nomenclature of their profession. And if you are, as an attorney, haven't encountered the details of that before, you really need to work out a way to dialogue and to talk about it. And the way I often express it to folks is, look, you are the expert. You need to teach me. Teach me why what you're telling me is important. And then I will teach you about how the law may or may not apply to what you were talking about. So I think if we look at it as a collaboration rather than a direct I'm the expert, you're the expert, we can't connect, then I think you have a much better chance of success. So that's the other element. Expertise is one, but another element is you've got to find somebody you can communicate with, somebody who is interested in understanding who you are, interested in understanding what you've been through, interested in understanding what your profession is about. If you get an attorney that's, kind of poo-pooing, understanding some of those details, you're in the wrong place. You should have someone who really is going to work with you and understand and develop, collaborate with you on a set of goals that makes sense for your situation. And reputation is another thing that could be very important. I'm not saying that one has to find the most highly acclaimed lawyer or law firm in order to do a case, but do investigate to whatever extent you can the reputation of the lawyer or firm to understand what their standing is in the legal community, because that can make a difference with respect to settlement, with respect to a whole host of things. So these are just some of the factors I think that would be very important to consider.
I just wanted to add, if I could, one thing quickly. I couldn't agree more with you that I view a client like my partner. We're there to partner and work with each other to make sure we can implement the client's goals. But it's so key early on to really understand clearly what are the client's goals, right? So for some of my clients, they've been harmed economically and they want to get a recovery. Some don't care about the money. They want to have their issue out there in the spotlight. They want to make sure their employer is going to do the right thing. They want to make sure people won't be harmed by their employer. Some of my clients want to get a reward. It is so key to know what is it that they really want and what can the law really offer them. And to also be very upfront with the client that certain things that they want to do could create huge risks for them. For example, if you work at a U.S. government agency, you can go to the media to blow the whistle as long as you're allowed to use that information you're blowing the whistle about. If you work in the private sector, the laws don't apply as well if you go to the media. So really knowing all the downsides, all the upsides. There are many people who call me and I realize early that what they want is just not something that I would be the right fit for. So I refer a lot of people over to the Government Accountability Project and to other organizations. But it's really important for you to know what your client would want early on, because once you get into that lawsuit, it can go for years. I have had some go for 8 years, even more.
No, I think you're raising a really good point, because so many times I'll get a call, a panic. So the organization wants to settle and they want to know what I want for settlement, and what should I say? And I'm like, well, haven't you had this discussion with your attorney? That should
Jackie,
be
your query hit on something that's a major part of Government Accountability Project's work, because we get so many more people seeking representation than we have the staff to do justice to the commitments for their cases. And so I think it's a very, very significant question that you're asking. So there's a little bit of some overlap with Richard and Jason, but I think it's a good thing to summarize and have clear coming out of our panel. And I'd say the bottom line theme to answer your question is do your homework first before you make a commitment to counsel. This is one of the most significant relationships of your life. It's high stakes, intimate relationship, and not romantically intimate, but intimate, in which you have to be open to sharing all the things that you don't want anybody else to know, because it's essential in order to achieve the things that are most important to you in having a life And so it's extremely significant decision that I wouldn't do it on the basis of a good first impression, just one interview, and do a lot of homework and checking. And kind of the things to check to me for whistleblowers, what is the lawyer's track record at the firm where they're working? Second, what's their personal background? Being an effective lawyer means having good relationships with the opposing parties, or at least effective relationships with the opposing parties. They may not be so friendly, but relationships of respect, and a lot of times that comes out because the lawyers that you're working for have a history. For example, in the government agency, it's like, why you look for a former prosecuting attorney when you're in trouble and you want to stay out of jail? You go to somebody who has a history of working with prosecuting attorneys and is familiar with that world and effective. What's their background? The third thing is, do you want a problem solver or a warrior? Which Jason was going at. Some lawyers are, I mean, they're really fire and brimstone. They're great at slash and burn tactics. That is not going to allow you to heal with the adverse party. So do you want to destroy the adverse party, or do you want to try and see if we can work something out, or we can still have work together, or you want to have a result that's constructive for you, but is not going to identify you as a threat to the next employer? Which type of personality of the lawyer makes all the difference in that. The fourth thing is what Jason pointed out. This is a partnership. Are they open to having a partnership? I mean, there's a lot of lawyers, they're like the client's boss. And lawyers are, hard, aggressive, strong personalities, and they're kind of, the nobility of their operations, like, the king of their law firm, if they're it's their own firm, and they're used to telling people what to do. Well, I don't think that's the most effective in a whistleblower case. This really requires an effective partnership and a lot of listening. And finally, since it's a relationship that requires trust, start earning that trust right away. Is this a lawyer who's open to discussing the ground rules for the partnership? Like the provisions in the retainers, just take it or leave it. Here's our boilerplate retainer that means that you have no rights and I have all rights in the event of a dispute between us, and got to sign this, or we got nothing else to say to each other. Or is it, how are we going to be effective as a team working together? And you want somebody who's open to having that conversation from the beginning.
No, Tom, I appreciate that. I once had somebody to say to me, you don't hire an attorney, you marry one. That they know you in and out, and they become your partner for years, sometimes lasting longer than some marriages, because as we've said, some of these cases go on for decades.
Jack, if I could just say that, I mean, the U.S. Ethics rules that usually are issued at the state level, but most of them now are basically out of the ABA model rules, are quite clear. The client is always always has the ultimate call on whether to resolve a case, what claims to bring, where to go with it, and the lawyer always has to answer to the client. But what becomes hard, so I mean, what I always tell my clients is, you're the boss, I'm here purely to carry out your goals and your objectives, but I have an obligation to make sure you can make an educated and informed call, so that you know the law, you know all the pros and cons. The hard thing, which I'd like your insights on, Jackie, at some point, is what happens, and I don't get this often, but what happens if you get a client who's not willing to listen, who wants to do something where any lawyer they go to would give them the exact same advice, no, or a client who has an unbelievable offer, where if they go to trial, you know, it's not looking good and they're not even willing to look at that offer. Like, what do you do when you have a client where you give them the law, you try to arm them with all of the information they would need in order to make a decision, but they just have a very closed mind and they're not willing to look at anything that is at odds with their view. That gets hard. I don't know if any of the other advocates on this panel have dealt with that issue. I don't see it often, but I've had some where I put in, you know, a few hundred hours of work, maybe even more, and a client wants to do something that's just not in their interest. I know that any other lawyer who's experienced would look at it the way I'm looking at it. And ultimately, it is my client's call. And if they want to pursue an action that's not in their interest, what do you do at that point? That's a really hard issue for us as advocates.
Yeah, so from just, if we're turning this around a little bit here, if I had to answer that question, I would encourage as much as possible that person talks to their family, talks to their therapist, that it isn't just this one, you know, it's not just law firm client now. This affects a lot of people's lives. So how do you work through, again, these are trauma survivors. I think you have to take that trauma-informed perspective and realize that that tunnel vision that you're dealing with comes from being traumatized, that people don't see the settlement and the end of the case as viable for lots of reasons. But I think that, you know, being able to talk that through and getting that, that's why I always say whistleblowers need their own army. So it's, do you have an attorney? Do you have a therapist? Do you have your family? Do you have your chaplain? Do you have your peer support personnel? Who is helping you problem solve and make decisions, and then be resilient? How do you experience that post-traumatic growth that should come from having dealt with your trauma? So I think that is key. Is how do you know? And then, you know, how do you decide, like, what is, going back to the question about evidence, how do you decide what's good evidence? So, and I know we've had a question in the Q&A about do lawyers, is it helpful to go to the police, the FBI, Congress, and get those people involved? Is that a better, or is that a good way for clients to expand the scope of their case and protect themselves? Oh,
They have to.
Yeah, okay, and then Tessa.
Jackie, they just have to. Without solidarity, it's isolation is the fatal word for whistleblowers. And so at Government Accountability Project, our whole strategy for all the cases we've won over the years has been, we don't call them legal cases, we call them legal campaigns. And you play, you know, we're information matchmaker between the isolated whistleblower and all the stakeholders in society who should be benefiting from their knowledge if it only hadn't been kept sacred and concealed from them. And when that happens, instead of a corrupt bureaucracy surrounding the isolated whistleblower, it's society that surrounds that organization. And they're getting it from all angles, from the politicians, from the competitors, from the regulators, from the law enforcement people, from the stakeholders, from the victims of their misconduct. They get surrounded by the truth. And so you get into as many hands as possible.
No, I appreciate that. Thank you. And Tessa, did you want to add something?
I was only going to say, in response to Jason's comment, I appreciate your difficulties, and I think yes, the client's always right, except when the client is wrong. And that's the same time, you know, if I just go back to my previous experience of being a representative of local people in Parliament in Westminster, in London, and people would come to me with cases, and a few of them were whistleblowing. Some of them they thought were whistleblowing, but actually they were complaints, and different things altogether. And the best thing to do is to engage somebody as well, to make sure, as you said, I can't remember the word you used, we call them counsellors, but you know, your therapist is the word you would use, I think, isn't it? But to make sure that there is somebody who can explain the full implications and go through the full implications and the implications of any move in the difference. And the difficulty is when somebody's inside their own case, they know all the detail. And being able to engage with, in your case, Congress, in my case, Parliament, to be able to engage somebody else into the battle, it's almost, the detail is too much. It's not something that people can get a grip on. If I go back to that Catherine Gunn film about, you know, having whistleblown in our most secure environment, about things that the government was doing, most people can get the big picture stuff, which is where I think it's so difficult to get other people, you know, to get people involved. I saw somebody's comment on the chat about, you know, we're our own filmmakers, we can use social media, but very often it's quite hard to convey in a relatively short time the message of what is wrong, what's happened, and what should be done to put something right. You can certainly put across the injustice that whistleblowers feel and experience. People get that. But actually, as far as you lovely lawyers are concerned, I suspect you definitely need somebody on board who is the other party, who can simplify the language and make sure that somebody understands the simple concept of the steps they're about to make and what the implications are of that.
Two quick things, Jackie. One of the things we try to do, if it's a good case that we're really going to go to trial, we try to get a mock jury, right? Where you try to present your case and the other client, the other side's case, because both the client and the lawyer might see it a certain way because they've worked as advocates on this case for years. And it's so important to try to get a sense of what would an average jury believe about the evidence, and that can be a helpful way, you know, to get a client to rethink their view. But to your other question about whether to go to the Hill to get help from others and do a lot of other advocacy outside just that legal claim. I've done that on behalf of a lot of clients who work for U.S. government agencies, meaning going to the Hill, going to OIGs. I would agree that that's always a good idea. In the private sector, it can be helpful, but I think there you really have to think it through very carefully. One, as I always tell my clients, everything they do from the moment that they bring a claim, they should know the other side is probably going to have access to. Meaning if it's not an email to me or their spouse, the other side's going to get it. So if your client is emailing a lot to people on the Hill or to other people in the US government, they're likely to have to hand that over. So you just have to think it through very, very carefully to make sure there's nothing in there that's at odds with what they have alleged in their complaint. You also want to just think through what's going to be the impact on the employer, and also what's going to be the impact on, you know, the judge and the jury. So if your client goes, let's say, to the SEC and they make a lot of noise and the SEC never, ever acts on the information, which happens often. If I'm the employer, I'm going to argue to the jury, look, this person went to the SEC again and again, and they didn't do anything at all. So I'm going to argue maybe that plaintiff did not have an objectively reasonable belief that what they blew the whistle about was an actual violation of SEC rule. So I don't want to get into too many of the details, but if you have a claim, and again, this is one of the areas where it can sometimes be hard for me to work with clients, because I do tell clients, if you want me to put a huge amount of time into your case, I need to know if you're ever speaking to anyone else, what you write, everything you do can have an impact on your claim. So it can be worthwhile to go to the Hill, but you just really have to have a good plan and really know what could be the ultimate impact of that other advocacy outside of the legal process.
Can I go back to Jason's earlier point about the situation that sometimes develops where clients have an expectation that's counter to what the law, the facts will even, counsel for in terms of action by the lawyer. I do think that does happen. And I think with some clients, it happens as sort of part of their evolution in the case, and they adapt with the lawyer's help in terms of understanding what the limitations of the legal system are. But sometimes there are those that don't adapt, that don't recognize the limitations. And when that happens, I think one of the approaches that can be successful is to have others in the law firm, for example, that have not been involved with the case, sit with the client, hear the client out, talk it through a little bit. I agree totally with what Tom and Jason were also talking about, and Tessa to some extent about, and you, Jackie, about the support system. Like, what does your significant other think about this? What have you engaged account? Do you have a therapist or someone you're talking to about these things? I think it's not insurmountable, but it does become very, very awkward, because the other thing that clients need to understand is we have ethical limitations as well. We are technically officers of the court, which means that there is some limitation to what advocacy we can bring. This is thankfully highlighted by the recent sanctions that are being taken against the various lawyers that tried to claim that the presidential election was a fraud based on no evidence. Okay, so great example of application of standards. So there are those limits for us as well, and it's helpful for clients to understand those things. And we try to build into our discussions, all of these different elements and how the client might have to be thinking as the elements come up in the case.
So I want to address the sort of the elephant in the living room is litigation is expensive, and so I love this question. So how do you advise clients who see, they're going up against large organizations? They have their own in-house attorneys. They're able to bring in some very prestigious law firms, and then they come in for these depositions and trials. And then there are 6 attorneys for the defendant, and you have your one single attorney. How do you afford that kind of a litigation? And then is it acceptable to go and get a third party, an independent review of your case, and sort of a second opinion on the advice your attorney is giving you? So how do you do all that? How do you afford all that?
I could start with something which is, in the US at least, under almost all of the whistleblower laws, if you win, the other side is supposed to pay for your legal fees. Often they get slashed by the judge saying we worked way too many hours, even though there were 8 lawyers on the other side and they billed millions of dollars. But in any event, that is very helpful. But I have my clients at least pay the out-of-pocket expenses, which can really add up. Again, you really have to look up front at what you're going to have to pay. Not only that, I have to tell my clients, if we're going to go into federal court and we don't win, you could have to pay part of the other side's out-of-pocket costs, not their actual legal fees, but their out-of-pocket costs, which if we're going to federal court with a lot of experts and stuff, that can add up very quickly. I find, on a positive note, that the really good claims do get resolved at some point. If you really show the evidence is good and you're likely to win when you go to the jury, I find there are opportunities to get these resolved. But no, it's a huge obstacle. And I do want to just say, on a positive note, I did have one of those cases a few years ago where I literally, when I'd go to deposition, it was me and my client, and we had 8 lawyers on the other side. We had 2 in-house lawyers, 4 lawyers from a big firm, and then a few lawyers from this other firm that was also helping. And I kid you not, I still got what I wanted out of those witnesses. I remember there was an officer on the other side of CFO. They prepared him for 40 hours, but he was so over-prepared and under so much pressure that I asked him one question, and he went on for half an hour and gave me everything I wanted. And the lawyers next to him were beginning to kick him and to try to get him to stop speaking, but he gave me what I wanted. I find, you know, if you can outwork the other side, if the evidence is good, it really doesn't matter how many lawyers there are on the other side. You can get the right result, but where there are good opportunities to get something resolved, you really have to analyze closely who's going to be your judge, who's going to be the jury. A lot of judges don't allow cases to go all the way to the jury, and they're all too happy to weigh the evidence for the employer. So you just really want to look where there's a good opportunity to get something resolved. You want to look at that closely. Maybe it can be helpful to go to mediation. Again, I find if a case is really good and the employer has a good outside counsel, there are usually opportunities to get the claim resolved at some point.
Yeah, Jackie, you should know that some court rules provide for early mediation or evaluation. And that can be a very useful element in the case because it allows for the client to hear from a third party what that party thinks about the strengths and weaknesses of the case. So you're not too far in, you know, you haven't spent zillions of hours yet, or you know, tens of thousands of dollars on experts and other things. And I often recommend, if it's an option, for clients to engage in that process with me, because you know we all learn something from that process. Even if we end up disagreeing with the mediator or the evaluator, you absolutely learn things from a process like that. And so it's very worthwhile if you have that opportunity.
I can offer a few additional points to answer your question, because it's so fundamental. Can you afford your rights? And the first is something for the whistleblower to bring up in those advanced negotiations with the attorney, that they'll keep the bills down by doing a lot of the work themselves. You know, there's a lot of law firms will say, "Don't worry, we'll take care of everything for you. You know, we'll take your laundry to the dry cleaners for you." It's getting $500 an hour to do it. And the more work we do, the better. Nothing's too petty for us. You know, this is a different dynamic, and an awful lot of the work can be done by the whistleblower. Digesting the documents, looking for a particular type of information that's buried in the files. A second thing to keep in mind is due process is very expensive, going to court, but acting on your rights doesn't need to be so expensive. By filing a complaint for one of the remedial investigations, almost every whistleblower statute starts out with stage 1 as a remedial investigation by Office of Special Counsel or the Occupational Safety and Health Administration or the Office of Inspector General. And you know, they're not in the same league as due process in terms of your control over how the record is developed and the outcomes, but it is a chance to act on your rights. And when you combine a remedial investigation with an effective legal campaign, that can very, very frequently, as in our experience at GAP is the rule, overwhelming rule, force the other side to kind of come to the table and resolve the case in a manner that doesn't destroy your client, that allows your client to get on with their professional lives and can resume them. So it doesn't have to be the 5 or 6 figure budget. And kind of consistent with that is the reason that things get resolved at the more administrative level like that is because the organization knows that it's the lawsuit's going to be more painful for them than it is for the whistleblower. Information is going to get put out into the public record that they don't want anybody to know about it. And continuing the dispute is going to just totally demolish their capacity to have any influence over keeping things quiet. And that means that sometimes, even though litigation is expensive, you can do it because it becomes the trial of the wrongdoer, not so much just the trial of the retaliation, but the trial of the wrongdoing that the bullies were trying to cover up. And when there's been litigation starts against GAP, they've been wonderful opportunities for fundraising to have a big production out of this attack. And so there are ways to try and turn it around.
So I think that one of the other things that, so to take 2 points and sort of pull them together is where I'm trying to go here, is, so we've talked about like what it takes to win and then what it takes to when you're hiring an attorney. What is it or that it takes for the client when they come to you, like how prepared, what's the strategy? When you look at what they have, like what are some of the key things that the client needs to bring to you for you to say, hey, this is a really good case and I think we could win. I think a couple of you have said that, oh yeah, it's a case we could win. What makes you think that? What do you need to see?
Well, I think, Jackie, what I need to see initially is I need to see the person and I need to understand where they're coming from and what information they have, what was their position in the organization, who was around them, what types of evaluations have they received, particularly when there wasn't a controversy. Because as we often see that evaluations somehow magically start to change when one is raising issues within the organization, where previously the person was outstanding, they're now just satisfactory or something like that. So, you know, that kind of evaluation history is really important. And to the extent that the person received or generated documentation associated with the issue, and by that I mean, you know, the emails that they may have received or they may have sent, I'm interested in at least a certain level of that information initially, but I want to caution folks should not go taking bunches of documents that they think are, you know, somehow going to, you know, prove their case. There are people that have gotten, you know, had their cases cut out from under them because they took a terabyte of information, you know, out of the company. Rather than some focused information that was associated with their direct whistleblowing and the experiences that they were having. There's a certain amount of protection that one has when revealing information, presuming that it's not classified or not protected in some other way, that you can certainly at least share with the lawyer that you're considering hiring for your case. But folks need to be very careful about the scope of what they take and should probably get a lawyer's advice if they're still working, as you know, before they begin to, you know, provide any particular documentation in depth. So I really want to get to know them and their position and what happened, and then maybe get into whether we need to start to talk about documentation and other things.
I would say a few things, Jackie. I like to see that my client did their homework, that when they blew the whistle, they really made efforts to ask other people in the office how do they feel about this issue. They really had the evidence, and that they wrote something. So as a matter of law, you can blow the whistle orally and meet that element of your claim. As a practical matter, because people are likely to be deposed years after the adverse action. They're going to deny that your client blew the whistle. So I really prefer for my client to write something very detailed. And it's hard because I go to my clients and say, you were so concerned, why didn't you bring it up? Well, we were warned not to put an email, or I knew that this other employee blew the whistle and he or she was out. So it is not easy if, to blow to write an email to your boss or higher up saying, we're violating the law. You might lose your job if you do that. But in order to win the claim, I really want to have clear evidence I can blow up for the jury. I can go to the judge, because what happens sometimes is a client might write an email. It's kind of vague, like we might be violating this. This might not be okay. And when my client tries to offer up an explanation, well, when I wrote that, I really meant this, this, and this. A lot of judges are just going to look at that email and say, this is what you wrote then, and that's what I'm going to hold you to. I want to look at the history of the issue my client blows the whistle about. What's at stake for the employer? Is it that they weren't willing to spend money in order to resolve an issue my client brought up again and again? If I can show that, it makes it more likely than not that the employer had a strong motivation to go after my client because they blew the whistle. I do want to look at my client's prior employment history and stuff. And I'll be blunt about this, and I hate to have to say this, but I want to ask, will the jury like my client, right? I mean, does my client have any allies? When I ask a prospective client, are there other people I can speak with, you worked with, who will be able to vouch for you, who are an ally? And if the answer is no, there's no one, that's probably not good. I mean, let's be honest. You don't have to, under the law, be an individual that everyone got along with. And certainly when you blow the whistle, there's going to be a lot of resentment. But as a practical matter, if you're going to go to the jury, you want to have someone that a jury is going to be able to empathize with. So that can really, really matter how your client will present themselves. And you don't always have to blow the whistle in a very polite manner. And certainly if you blew the whistle again and again, and there's been a lot of animus, you've been ignored at some point, you're not going to blow the whistle a polite way. But, if you're present at a meeting with a bunch of other people and you're blowing the whistle and you make sure to use, the F word again and again, and you don't show any respect whatsoever for your boss, there's law all over the map about whether or not that'll be legally protected, and it probably is. But how's that going to play before the jury, who might just say, well, I wouldn't want to have someone like that working under me. So those are some things you really have to look at.
Jackie, I can kind of summarize this. It's a very, this makes a lot of difference in your ability to find a lawyer. If you have your act together in advance in a way that impresses the lawyer, they're assessing whether you're going to be a good partner with them, as you're hearing from Jason and Richard. And I think one of the most basic things that's very useful for a lawyer to have is a chronological timeline of the key developments in the case that puts things in perspective for them. It's just one of the foundation documents the lawyer is going to want. And if the client already has that, when they come in, the lawyer is going to be impressed. The second thing is assessment of available supporting witnesses. Part of it's what Jason was saying. Everybody hate this guy, and it's going to be, the jury's not going to like him either. But part of it's just being able to prove your case. Isolation is fatal. Tell people, no matter how much I believe in you, I don't want to send you to hell if you're not going to be able to come back. And if you don't have anybody supporting you, you're going to be stuck there. You have to make an honest assessment of that, realistic. The third is access to documentary support. Richard's absolutely right. You don't is it may be a big strike against the whistleblower if they already have the documents, because they'll be liable civilly or criminally for stealing them from their employer. But you need to know that they are going to be able to prove the case. And Government Accountability Project survival guides go into some detail how you can preserve the evidence without making yourself liable for taking the evidence, but have it there to be able to defeat the cover-up. And then the fourth thing, which I could have put first, but it needed the context, is anybody who's coming in to look for a lawyer, if they can have a 1 to 3 page summary of their case that coherently includes the key, most significant facts, their objectives, what they want to accomplish, in a concise manner, summarizes what happened to them and has the most significant facts for themselves and the public, and you can do that in 1 to 3 pages, there's nothing that's going to earn a lawyer's confidence more, that you're going to be a functional, effective partner who can communicate. Which becomes the bottom line in any showdown. So those are sort of 4 things that I think folks who are looking for a lawyer can really put themselves on higher and higher ground in terms of being able to have the lawyer that they want pick them too.
I know we're coming to near the end here of this session, and I've had a couple of questions about what it takes to win on an appeal. So if I can get you guys to maybe just give us sort of the best advice you would give somebody who was trying to appeal their case. What are some of your thoughts about whether you take an appeal and how do you argue an appeal?
Appeals are generally, as a matter of statistics, are harder than winning an appeal is harder than winning the original case. Okay, so that's the first thing to understand. The second thing to understand is that to have a chance at winning an appeal, one must have a viable or more than one viable appellate issue. And typically you're going to do better, or you have a better chance, if the appellate issue is a question of law. In other words, that the lower court or the agency screwed up interpreting the law. Like they didn't get the burdens of proof right, or they didn't understand causation, or they didn't apply the evidence correctly based on the legal structure that's appropriate for that case. If you're just going to argue about the facts, and a finder of fact has made a decision below after seeing the evidence, seeing the witnesses, weighing that and making a judgment, you're going to have a really hard time. And those appeals where the issue is whether you agree with the factual decision or interpretation are long shots at best. That would be my quick summary.
Okay, I appreciate that. Thank you. So I don't see any other current questions here.
Can we address one other thing real quick, because I think it's so important?
Sure.
It's been mentioned a number of times, and I just wanted to sort of close with this in a way, and that is, and all the panelists have mentioned this, and Tessa included, this issue of moving on, this issue of closure and moving on, I think is really, really important for people, for whistleblowers to actually spend time working on and thinking about. No matter how the case or issues you're working on resolve themselves or don't, the person needs to have a plan and a way and support to figure out what moving on is going to look like. Because whether you win the case or not, you're going to come to a point when the various elements of that case or campaign, as Tom would put it, are over or essentially done for all intents and purposes. And one really needs to think through carefully what that means for them personally, how they'll address it, do they have support to address it? And I think that is just really central to the person in these issues. And so I wanted to, just make an exclamation point there.
Now, as a follow-up though to the last question about appeals, I've had a question about what if it never gets to a find of fact or it gets to go before a jury, I think is what they were asking about. So the judge never sends the case to a jury.
Well, that sounds like it was a determination of the law. And the question would then be, did the judge make a correct determination or the agency make a correct determination of the law? And if one, if a lawyer looks at the precedent, looks at the interpretations of that law and sees that that judge or final decision maker has likely made an error, then that can be a pretty viable appeal. So that's, it sounds like that's what the questioner is asking about, is kind of a legal question issue.
Okay, and then, so I have had a question about going back to, I guess, whether or not you should engage with a therapist, is how could that information then be weaponized and used against the whistleblower? And we discussed this a little bit in the previous panel about getting a therapist involved. Could that then become something to the detriment of the whistleblower when it gets disclosed to the other side that they've seen a therapist or a clinician?
Obviously, it creates a vulnerability for a cheap shot that, say, that a person needed to go to a therapist a lot earlier, while they were giving us trouble, But I mean, it's a cheap shot that would, kind of like a bluff that's easily called. An effective therapist will give a diagnosis that, the problem here is harassment, not the judgment of the patient, and it arms the whistleblower with some professional credibility, because they're going to be branded as crazy, and unreliable and not credible anyway. They're going to be trashed that way. So this gives them something which is tangible and legitimate to fight back with, and also often to turn the tables. Say that the pathology here is the retaliation, not being the object of it. So I think it's something you absolutely have to do. And further, it can be preemptive. Because a lot of times an organization will try to force that on the whistleblower, and then they're going to be pushing you towards their experts, and so it's kind of stepping in front. So no, I think it's something very, very valuable.
I agree with Tom's observation, but much like choosing lawyers, choosing therapists is very important.
Yeah.
Having a therapist that understands what goes on when you're a whistleblower. Not every therapist understands that. And, I think that's very, very important, is to get with someone who is going to appreciate the position of the client in their situation, and maybe has even worked with other dissenters, ethical resistors, truth tellers, whistleblowers, however you want to frame it, previously, because otherwise they may well look at the client in the same way that the employer does. Oh, you're being unreasonable, you're being difficult. Let's see if we can work on your skills to, get through that. What makes you be so difficult? All these sorts of things, instead of coming at it from another approach, which is this person is actually standing up and doing something that's making him or her the object of attack, because they're doing something important. They're raising something that matters. So I totally agree with Tom. But I do think that choosing the therapist is really, really important.
Well, Jackie, it kind of raises a suggestion. One of our functions at GAP is having an attorney referral list of trustworthy, knowledgeable, effective counsel that we can send to people. And one of my most common activities is sharing that. It may be something for Whistleblowers of America to have a therapist referral network, and a lot of us lawyers will be getting in touch with you for it.
No, I think that's part of why we want to do the Whistleblower Protection Advocate, and we do. We've been trying to work with the American Board of Social Workers. And I should mention that we are trying to get if not this session, then the recorded version of this session for CEU credits. And I believe we have a couple of attorneys that are monitoring this, and they're going to take what they can and try to get CLE credits for this training as well, so that we can start to establish this training and this perspective as an important element of understanding the psychosocial dynamics of being a whistleblower and what it takes. So I appreciate all of
Can
the
I interject?
encouragement. Yes.
That is so helpful. And to the extent you and allies can get a lot of peer reviewed research that we can then use when we go into court, and we can get in, you know, we can offer up our experts and really hope to make law to show what is the long-term impact. Why is it that it's a huge problem that the average award for non-economic damages in these cases is very, very small. It's usually way below $100,000. The more that your organization can do to get the word out about, okay, it is widely viewed by real experts in this field that there's this long-term impact when there's an act of retaliation because you put your neck out there, you put your job on the line to do the right thing, and then you lost your job, but there's another act of retaliation. Where it is widely known, what is the impact of that? I think that will be very, very helpful, and we can hopefully get higher awards for our clients that then other people will be able to use.
No, so again, the panel just before this one, that was a big part of the purpose of that panel. Ian Foxley and James Gillian were on to discuss what's paresia, how are we organizing the research, how does the research inform legislation, and then how does that inform our ability to take those resources and that evidence base and say, myself, my client was harmed by this type of retaliation. It caused a serious injury that has led me to now be stressed, depressed, at risk for lifelong unemployability. What are those factors then that we take to judges and juries and show that there are these damages? I call it mental health parity. How do we prove that having your identity disrupted and your ethics and your worldviews shattered, how is that as harmful to you to be a productive, socially involved, so you previously had a successful career, you've been a whistleblower, and now that whole cycle has been disrupted, that you are then now have been victimized in such a way that you deserve to be compensated for it, as if, you know, you lost an arm or a leg while performing a job. It's the same injury. It's just as life impairing, and we need to understand how to compensate for it. That's why I know I talk to a lot of times to attorneys who do VA disability benefits, because there's a similarity to that. Combat veterans suffering from PTSD are able to go through a VA disability claims process and be awarded sometimes up to 100% compensation, which can roughly is about a $3,500 monthly benefit plus whatever else. But those benefits become lifelong. So over the lifetime of a veteran, they can be obtaining a benefit, a compensation, because of the post-traumatic stress disorder that they've experienced either in combat or as a personal trauma. So there is this recognition that personal trauma can be as impacting as combat trauma. And I think our goals for today, and we're coming into the lunch hour. So if anybody has any closing remarks, I would welcome them. And I really do want to thank you. I know you guys are very, very busy lawyers and working on cases all the time. So the fact that you took 2 hours today really means a lot. And I think was very helpful to hear sort of the perspective of the other partner in this marriage, what it is you are thinking and responding to, and what makes a case successful from your perspective. So thank you.
Thank you, Jackie. Really appreciate the opportunity to be here and to speak to you and to the folks that are online. And I want to thank Tessa and Tom and Jason. What a great set of panelists to contribute to this discussion, especially Tom with his depth of experience and working on all the legislative elements. He needs to be more often applauded for almost single-handedly making whistleblower law a reality in the United States. And I look forward to maybe checking in with Tessa and her organization and learning more about what's happening in the UK. But thanks very much. Really great experience. Appreciate it.
Yeah, Jackie, it was an honor to be on this panel, and I really applaud all the work that your organization's doing.
Great. Well, thank you. And because you guys are attorneys, and I don't know if there are other attorneys, I know Joe Wade, who's on our board, he has put in sort of what are the requirements to get CLEs for this session or for the entirety of the session. And we will make the program and some of the written materials are going to be available. The recording will be available online. Again, thank you. Thank you.
Jackie, can I just say very, very quickly, thank you very much indeed for letting us join you. It's been an absolute pleasure. I've learned a lot and I've got some good ideas for the future. No, it's cool. And maybe by the time we come back to you next year for your next annual job, that'll be brilliant. And maybe we'll be able to talk about the Office for a Whistleblower as Office of the Whistleblower in the UK as a reality. Thank you so much.
Oh no, thank you. And I've been tracking emails about you want me on the panel tomorrow for Cambridge. So I love the networking.
Thank you for having us, Jackie. It was fun. And I'm giving my law school clinic students clinic hours and credits for watching the whole Workplace Promise Institute, because I think it's just so significant for our movement.
Thank you. All right, I see Christian is coming back on, which means it's lunchtime. So we're going to end this session. The line will stay open though. Christian is going to be talking over lunch if you want to go grab a sandwich or something. And then anybody who wants to just have a one-on-one chat with her about the Whistleblower Protection Advocate Program, what it takes to get certified. And then after lunch, we'll come back 1:30 Eastern Standard Time, and we'll be discussing the introduction to peer support skills for addressing psychosocial impacts. And Christian, Carrie, and Gabby will be joining me for that. So thank you. I'll see you all after lunch.